Peace, what's going on? Super Lawyer here. You can check me out on soupalawyer.com, soupalawyer.com. This is Super Today. I'm going to get into a situation that happened to me. I caught a case a long time ago. I went to pick up a friend. Friend had jumped in my car. Police had, as soon as my friend got in the car, I pulled off a little bit. Police surrounded us, pulled us both out the car. I had something light on me. They arrested me. They arrested her. They charged me with possession with intent, paraphernalia. What happened was my friend was being set up by somebody. The person that was setting my friend up was in my friend's house. So I guess the police had sent this confidential informant to my friend to set my friend up. And I was just giving my friend a ride. So when I got my police criminal complaint, I went to the preliminary hearing. My lawyer put the officer who arrested me, well actually it was a detective, put the detective on the stand who arrested me and asked the detective, did your confidential informant get any drugs this day? The detective said no. Right then and there, my case should have been over with. Actually, I was charged with delivery also with the other 3 offenses. Right then and there, my case should have been over with because the CI never was provided no drugs this day and I was charged with delivery. As far as what was on my possession, on my person, then that evidence would have been suppressed. Once the delivery was gone, then it shows that the arrest was illegal and that anything obtained off of me was obtained from an illegal arrest. So if the arrest is illegal, the search was illegal and all the drugs got to be suppressed. So the case was not supposed to go no further at that point. So what happened was as the preliminary hearing went on, at the end of the preliminary hearing, when the detective got off of the stand, the district attorney asked the district attorney asked the magistrate to amend the complaint. So what the district attorney wanted to do was change the date from the delivery that I was charged with delivery to another date where my co-defendant had made a delivery on another date that I wasn't even around. So my lawyer objected to it and was like, due process is not afforded to me at the end of the preliminary hearing, meaning that due process, in order for due process to be satisfied, I would have needed to be arrested and provided a police criminal complaint. So due process wasn't satisfied at that point at the end of the preliminary hearing. So the district attorney asked the judge to amend the complaint to change it from the one day that I was defending myself against to another day where my co-defendant had made a sale to the same confidential informant that was in my co-defendant's apartment. So several things happened in this case. I mean, you got a situation whereas I'm prejudiced by the amendment, meaning that if the DA changes my police criminal complaint from one day to another day, then what he's actually doing is taking away from my original defense. He's taking away my chances of getting this evidence suppressed that was obtained off of my person illegally. So now that he changes my date, I no longer can present an argument to the court and say, being that the arrest was illegal, the search was illegal, and I'm asking for suppression of this evidence. So I don't have that defense no more once he changes that. So we run into that matter of my original defense being taken away from me. We run into the matter of a due process violation that I wasn't arrested or provided a police criminal complaint. And we also run into a matter of subject matter jurisdiction. How can the court actually have subject matter jurisdiction over these crimes when the institution of criminal proceedings did not commence by the filing of a complaint or an arrest? Which, if you look at Pennsylvania Rules of Criminal Procedure, Rule 502, 1, 2, A, B, and C, you will see that this is the way criminal proceedings is instituted in a court case. So we run into several different arguments. So I give you this situation, the scenario of mine, so that way if you ever find yourself in this situation, you will know how to defend yourself. You always want to make an objection to the district attorney's request to amend a complaint. You always want to do that, and you want to make your argument and show how you're prejudiced by this amendment, whether it's a due process, it's subject matter jurisdiction. Also, always remember this, errors complained of at a preliminary hearing, once you go to trial, any errors complained of about a preliminary hearing, whatever happened at a preliminary hearing becomes moot once you go to trial. So I said this to say that any errors you have about a preliminary hearing, if it go past the preliminary hearing and it go upstairs, you actually want to appeal that, so that way you can handle that matter prior to trial. You don't want to go to trial, because once you go to trial, errors complained of at a preliminary hearing are moot. So you want to take a direct appeal and appeal whatever the matter is that you're complaining of that occurred at this preliminary hearing. This is Soup of the Day. I'm always souped up. Anytime you get information to help yourself, you know, it's a good thing. Soups makes us feel good. You know, pass this information on, Soupalawyer.com. You need assistance with litigations, I'm here for you. You can check me out on Soupalawyer.com. If you'd like to interact with a community of your peers, you could go on salpeers.com, SALPEERS.com. And also be on the lookout for the Don Heroic and Monica podcast, coming at you real soon. I'll check you here once again. Soupalawyer out. Peace.